Joining me now is Newsday investigative reporter Jim Baumbach. Thank you. We have Suffolk PBA President Lou Civello and Deputy Director of Policy at New York University's Policing Project, Josh Parker. Thank you all for joining us. We're going to start with you, Jim. Why do both Suffolk County and police officers agree to these kinds of deals where officers have to leave the force once they hit 20 years of service time?
Well, the first thing I would say to that question is that the people who can answer that question, Suffolk County Executive Ed Romaine, Police Commissioner Kevin Catalina, Labor Relations Director Jennifer McNamara, they all steadfastly and repeatedly declined our multiple requests for comments. And they're the ones who, it's not just them, it's generations of people in their roles who have agreed to these deals. So therefore, we're left to talk to experts. And the experts tell us that settlements inherently are negotiation. And a negotiation means that, well, logically then, the police department would want these people out for whatever reasons. And logically, these people want to save their jobs. So therefore, there's a middle ground where where they reach this deal where they have to leave on such and such date when they can access their pensions. One would think, logically, again, what the experts have told us is that would indicate that there was some kind of flaw in the county and the police department's argument to get them removed from their jobs where they would not win the right to do so before an arbitrator.
Okay, let's go right to Lou. You are the PBA president. What does the process consist of when it comes to firing an officer after misconduct? Take us through that.
Yes, well, first, I fundamentally disagree with the way this is being framed. Even in the question, Sherry, so I think the word that you're missing is alleged misconduct. Even in the case of a criminal proceeding, we would use the word alleged, but we don't feel it necessary to use that with a police officer. These are settlements, negotiated settlements, because as Jim just said, the county doesn't believe in the strength of its case. And, if not, they would go before a neutral arbitrator and abide by their decision. Instead, the process when there is alleged misconduct, and keep in mind, police officers more than anyone else, teachers, doctors, other union workers, receive false and bogus complaints, right? And these cases are cases where the facts are in dispute, where the police officers profess their innocence, and all sides come to a negotiated settlement. So the officers have due process. They have the ability under state statute, Section 75, to have a hearing, and also rights under our contract, which allow them to go before a neutral arbitrator.
Okay, thanks, Lou. Josh, I want to get your take on this. Now, you advocate for transparency and accountability in policing. What's your take on this procedure and the way things happen?
It's dangerous to allow officers who commit egregious misconduct to remain on the job just so they can collect a full taxpayer-funded pension later on. It is important to promptly terminate officers following full due process and a hearing, whatever procedural rights officers are entitled to. But it's important to promptly terminate officers who engage in serious misconduct, like excessive force, perjury, sexual abuse, or things like faking a breathalyzer test or giving up an undercover cop's identity, because that ensures that those officers are not continuing to put community members at risk or their own colleagues at risk by continuing to serve.
Lou, you partially answered this next question. Does the police department ever fire individuals on the spot after misconduct that is not alleged? Because if I ask you the other way, after misconduct, you're going to go back to the fact that it is alleged, I presume, yes?
Yeah, I mean, so Sherry, that's a bit like asking me, do you ever pull somebody over, right, and write them a ticket? And then do they ever go to court and the police officer is also the judge? The department does not play judge and jury. I would agree with your other guests that in cases where allegations of serious misconduct are substantiated, where you do have that hearing and you're found guilty, yes, then certainly you should be fired. That's not the case in these cases. These are cases where the department did not take these officers to trial, right? These are negotiated settlements. And again, that's why I object to how you're framing this. We make it as if these allegations were taken to a judge and a judge found the police officer guilty and the county, out of the goodness of its heart, decided, no, you should wait and collect your pension. That's just fundamentally false, absolutely false. And, we have a system by which you get due process. Compare that to almost any other union worker. Compare it to teachers. By teachers, they get arbitration in the statute. And I know your other guest is in the education field. So by statute, they're entitled to arbitration. And in their case, they're suspended with pay, right? So unless they not even are charged, but they're convicted of a felony, they keep their pay. In my case, my police officers go off the payroll. Many times, these trials drag on for 6 months, a year. They cannot provide for their families at that point. And that is the catalyst why they enter into the settlement, to get back to work. And in many cases, they go on to have very, very productive careers.
Josh, let's talk about how does this practice compare to other practices across the nation? That's something you look at, right?
Yes. So I haven't come across this practice where terminations or disciplinary processes are being delayed to the exact point in which an officer can receive their full pension, and at that point they separate from the agency pursuant to a settlement. This is the first I've seen this, and I was startled when I learned about that from the Newsday reporter who I spoke with.
Josh, I want to go to Jim. Could you give us an idea of how you approach an investigative story like this, especially in the case where it's at times often difficult to get folks to talk about it?
Sure. So it's obviously a challenge, and the biggest misperception, I think, of this work is that somehow it's handed to us, and it is not. We have this beautiful law called the Freedom of Information Law, where we can request documents from county agencies, from any kind of town agencies, from any governmental agency. And I had asked for police misconduct disciplinary records. This is going back 2021, 22, 23. They started to come in. We look at this from the standpoint of we don't know what we're reading. We're going to go into this blindly to see what is the truth here. And we want to be educated by the people involved. Lou has been great in terms of answering our questions. Experts have been great in terms of answering questions. It takes the work of a lot of people. I worked on it with colleagues Peyton Guyon and Anna Valiva, just going over these documents. What jumped out at us more than anything is I looked at over 100, I think it's 118 settlements. I read dozen arbitration cases. The settlements in which an officer agrees to leave, but at a future date, jumped out as something unusual, and it led us to ask more questions. And the one thing about that Lou mentioned before, I am very sensitive to the phrase alleged, to the word alleged. I think if you search to my stories, alleged shows up more than any other word. In this case, in those 7 agreements, all the officers agreed to quote unquote general misconduct. These agreements also did not tell us what that misconduct was.
Okay, good point about different cases and the use of the word and how it's applied. I want to thank Newsday investigative reporter Jim Baumbach, Suffolk PBA President Lou Civello, and Deputy Director of Policy at New York University's Policing Project, Josh Parker. Thanks, everybody, for joining us. You can read more about this investigation